Good morning. Thank you for joining us to today's webinar. Good morning. Good morning. Good morning. My name is Rosario Kamuti. I'll be your moderator for the day. Today we have a webinar on employment law. These are issues that affect many businesses, and we thought it was prudent to have a training on the various aspects that your business should look into, employment matters related. So this is under CM Advocates. CM Advocates is a law firm in Kenya. We have an array of practice areas, including commercial law, which is the department that is doing today's training. But we do have a number of departments. It is a big law firm. We have about 30 lawyers and branches in Kenya, Uganda, Tanzania, Zambia, and in Nairobi, and also have a branch in Coast. Now, today's webinar will be focusing on various areas. We'll start by defining employment and distinguishing between employees and consultants. You'll find out that the different contracts, there are two different types of contracts with two different requirements from both the employer and the employee. We'll also be looking at the basic employment conditions from leave, salary, the statutory deductions that need to be done for employees, the duties of employers, and what happens at the point of termination. This is the most important. The most important. All the others are important, but this you will really need to pay attention to, which is what happens at the end, how to terminate. So welcome to today's webinar. Let me introduce the speakers. The first speaker will be Susan. She's an advocate of the High Court of Kenya. She practices commercial law. She also does a bit of litigation. Myself, Rosario Kamuti, also under corporate commercial law. We also have Emily, also doing corporate and commercial law. We have Washera and Sarah, and we will also have Simon, who will also be starting off this webinar today. Victorine is also there. She is the head of the commercial department. I believe she will be assisting with answering questions. So if you have any questions, kindly put them in the question box and we shall address them. Susan, Simon, I think we can begin. Susan and Simon, if you're speaking, we can't hear you. Susan, Simon, we can begin. You can take us through the types of employment. If you have any questions, kindly put them in the question box. We shall address them as we wait for Susan and Simon to begin. Apologies for that. We're having a bit of a technical glitch, but they seem to be beginning now. Kipiria, can see your hand up. Are you able to type in the question box if you have any question?
Okay.
Just put any questions you have.
Can you hear me now, Rosario? Can you hear me?
Yes, I can, Victoria.
Okay. So I'll start the presentation for today's webinar by introducing the various types of employment contracts that we have. So we start with the oral contracts. So by definition, an oral contract is an employment contract that is agreed via spoken communication, but it's not written down. So I'll just run through the rest of the types of employment contracts. The other one is a written contract, contrasted now with the oral contract. A written contract is an employment contract whose terms are expressly set down in a document. So most employers in formal setting will obviously have written contracts drafted and given to the employees. We also have casual contracts. These are those which are entered into with employees who are engaged for not more than 24 hours at a time and whose payment is made at the end of the day. And then we also have probationary contracts, which are contracts for not more than 12 months duration, or if they expressly state that they are for probationary period. So a probationary contract must first of all, it has to be written down, and it has to expressly state that it's a probationary contract. You will notice that there's a lot of intersectionality between these types of contracts as we go on with the presentation. So there's also the fixed term contract, which is extended to employees who only work for a set period of time. So it will stipulate the period of engagement that the employee is going to be with the employer. We also have executive contracts. These are extended to high-profile persons in management roles. Here, I'd like you to think of maybe CEOs of companies. There are certain terms that may be included in their employment contract, which which contracts for other employees may not have those other terms, just because of the nature of their positions. We also have full-time contracts, which are offered to permanent employees who work a full work week, and part-time contracts, which of course, as the name suggests, they are offered for a reduced number of hours compared to full-time employees. Later on in the presentation, we'll be hearing about the requirement or the minimum requirement for the hours that an employee is supposed to work. So after running you through those various types of contract and just giving you an outline of what the presentation will look like, I will delve into the first type of contracts, which is the oral contract, and contrast it with the written contract. So we've already discussed the definition of an oral and a written contract. An oral contract can only be up to 3 months. This is a requirement of the Employment Act, which states that if a person is engaged for more than 3 months, then the employer must give that person a written contract. So an oral contract can only be for an engagement of 3 months or less. So where an employment engagement exists for more than 3 months, as I've said, the employer must have a written contract. So it is the duty of the employer to draw or to cause an employment contract to be drawn. That duty never shifts. It is the employer's duty to have the contract explained to the employee in a language that the employee understands. Where the employee is illiterate or cannot understand the language in which the contract is written. The contract also must be consented to by the employee, and how the employee consents to this contract is after it is drafted, then the employee must sign his or her name on the contract or imprint an impression of the thumb to symbolize the acceptance of the employment contract. So after stating that, we go to what particulars should be included in a written contract. This is expressly provided under Section 910 of the Employment Act. These are requirements or particulars that must be in that written contract that is provided for by an employee. Just by outlining on my slides, you can see that the name, age, address, and sex of the employee must be included in the written employment contract, the name of the employer, the job description of the employment, the date of commencement of the employment, the form and duration of the contract, the place of work, the hours of work, the salaries and other benefits, the intervals at which remuneration is paid. These are particulars that the law has expressly set out in the Employment Act as matters or issues that have to be put into the written employment contract. We'll also look at what is the advantage of having a written contract versus an oral contract, because the Employment Act states it's not a must for an employment contract to be in written format. It can be in an oral format. But what is the advantage of having a written contract versus an oral contract? First, you'll notice that the duties and incentives in a written contract are clearly outlined. So the employment, everybody knows their responsibilities as regards to the contracts. They know their obligation. So these duties are properly, they are clearly outlined for both parties so that there is no room for confusion, or if ever a dispute occurs, then we have a reference point of determining what were the duties of what party, what were the responsibility of either party. So that's one advantage as compared to an oral contract, where that clarity might not be there as much, because of course it would be who I said versus he said versus she said, and the problems that come with that. The other thing is safeguarding both the employers and employees, because the rights of both parties have also been enshrined in the contract specifically and expressly. So in written contracts, so that I know the employee's rights are defined clearly in a written contract, and so are the rights of the employer. And of course, if this comes to any dispute, we always have a reference point to that contract. So those are some of the advantages. The other one is the stability that the written contract provides. With the written contract, both the employer and employee have a comprehensive understanding of what is expected from each other, creating a stable work relationship. So there is that stability that a written contract provides, contrasted with an oral contract, so that the terms of, as you've said, are clearly defined, the term period, when I'm supposed to work from this period to this period of time, so that tomorrow you're not waking up and telling me, I do not need you anymore, or vice versa. Or yeah, so that is the kind of stability that a written contract provides. So you also notice that in terms of the employee's obligation, in contrast to the Kenya Employment Act, which imposes minimum standards for an employer or an employee, an employment contract can be drafted to impose broader obligation on the parties. Yeah, so you notice that the Employment Act only gives minimum standard requirements that an employee, I mean, it gives the minimum standard rights to an employee. But this can be expanded through a written contract. So when it comes to notice period, where the law specifically specifies that a notice period should perhaps be 28 days, that can be expanded, or it can be drafted to the advantage of the employee, giving them a larger or a bigger notice period than the 28-day notice. So the expansion of rights of an employee is also something that can also be enshrined in a written contract, which can be given to the benefit of the employee. A written contract also attracts workers, because you can utilize a well-written employment contract to entice candidates to work for you, instead of instead of the competition by promising job security. So there is a security that is created, and even we've mentioned about stability. There's that stability and security that is created when somebody is given a written contract with determinable rights and obligation, as opposed to where there is none. So those are some of the advantages that a written contract will give you, as contrasted with an oral contract. So it is preferable that you have a written contract anytime you are engaging in an employment relationship. So if you are an employee, you should of course insist on getting one. And if you are an employer, the law mandates you that after 3 months of engaging a person in a contract of employment, then you should give them a written contract. So the other thing we should look at when it comes to, so the other thing I would just perhaps touch on is what happens if there is no written contract between an employer and employee, and of course the engagement has been going on for more than 3 months. Does that mean that there is the rights of an employee cannot be enforced, or the rights of the employer cannot be enforced? And to answer that question, I'd say that a contract, even without an employment contract, the rights of the employee or the rights of the employer can still be enforced, whether or not there is a written contract, so long as the employee can prove that there's been a relationship of an employment relationship between the employer and the employee. So the only thing that the court will do is that they will interpret any terms that come out during the dispute to the advantage of the employee, because it was the employer's duty that was given to him by the Employers Act to draft the employment contract, and he did not do so. So whether or not there is a written contract, you'll find, and I say this because you'll find that a lot of us sometimes engaged domestic workers, and most of them do not have employment contracts. So to clear that up, and just to say, even without that, it's not that it will not be an enforceable contract. The court will still look at the facts of the case. If it's able to be proven that there is an employment contract between the employer and the employee, they'll still enforce the terms and conditions that apply within the Employment Act to that contract, and therefore, even without a written contract, then the employment contract is still enforceable. So we've also finishing now off on the oral and written contract, we transition to what we call casual contracts. And these casual contracts are contracts where the nature of this contract is such that the salaries are due at the end of the day. And also the engagement is for work that should be done for a period where the employee is engaged for a period not longer than 24 hours. So that's what a casual contract is, or a casual employment is. So you'll notice that for casual contracts, the employer is not required to issue any itemized pay statement. That is contrasted to, say, a term employment, where this is a mandatory requirement that an employer must issue itemized pay statements. You'll also notice that for casual contracts, the employment engagement, or that engagement for casual employees, it will be terminable by either party at the close of the day without any notice. So after you pay that, the person working for you or engaged in a casual contract, they can just go home the end of the day. You don't have to give them notice, and you'll say that that's the end of the engagement between the parties. So the other thing we're going to look at is conversion of a term contract, because there's a specific requirement by Section 37 of the Employment Act, which Section 37 of the Act, which provides that once a person is engaged for a period of more than a month. You've engaged a casual employer, you've engaged a person on casual contract for a period of more than a month, then that person automatically becomes a casual employee. I mean, a term employee. So that means they'll cease, the contract relationship will cease from being that of casual engagement to an employment engagement on term basis. Yeah. So the employment is engaged in work, and also the other instances where an employment is engaged in work that cannot reasonably be completed within 3 months. So there are two instances. One, you are engaged continuously for a period for a period equivalent to not less than a month, or either you are an employee engaged in work that cannot reasonably be completed within 3 months. So in those two scenarios, if those two scenarios occur, then your employment engagement automatically shifts from being that of casual engagement to one of term engagement. So we see a certain case law there is cited, Casey versus Kwale International Sugar Companies Limited, where the claimant worked for the employer's construction site continuously for 4 months. He was paid on daily basis. He was, however, terminated without notice, but the court held that that was an unfair termination. So you look at what are the effects of these conversions? So what is the effect of this automatic conversion that happens under Section 37 of the Act? Number one, the contract of service is deemed to be that of there's that transition from it being a casual contract to that being of a contract of services where wages are paid monthly. And the effect of that is that you can now not terminate the employee at the end of the day, as we had discussed, but you'll have to give a 28-day notice to that employee or to that person who you had engaged as a casual contract, because now the relationship has changed into a contract of wages, where a contract where wages are due monthly. Also, there will be the entitlement to service pay. So this, at the end of that termination period, if you had not, you are not paying NSSF contribution, or your employee was not enrolled in any pension scheme, at the end of the work or at the point of termination, they'll be entitled to claim service pay from an employer. Also, all benefits that accrue under the Employment Act to an employee who's engaged in term basis accrue to a casual employee whose engagement has been converted following Section 37 of the Act. So they are able to reap all other benefits that are provided for under Section 37 of the Act after the automatic conversion of their employment from casual to now a term employment. So those are the effects of conversion. So we also go over the issue of we also discuss some of the certain issues that arise under casual contracts. So a person will ask a question like, would a regular or permanent employment or a term employment be inferred on the basis that the payment was not paid at the end of the day? The answer to that is no. The fact that a regular or permanent employment, the fact that payment was not made at the end of the day does not disqualify a contract from being a casual contract. The courts will have to look at the facts of the case that are presented, and if the presentation of those facts represent a scenario where parties intended for there to be a casual contract, then that will not be affected just by the fact that the payments are not made at the end of the day. In that case that is cited there, Josephat Junguna versus High Rise Self Group, the court said that there are certain issues, certain administrative or logistical issues that might cause a person not to be paid at the end of the day. And that failure to make payment at the end of the day will not infer permanent employment to that engagement that the two people had, if that was not the intention of the parties. So that just answers that question. So finally, we look at probationary contracts. And the Act defines a probationary contract as one where a contract of employment which is not more than 12 months, it's in writing, and it expressly states it's for probation period. So by that definition, you get some of the features of the probationary contract. It must be in writing, expressly stating that it's a contract for probationary period. The other thing that we look at when we discuss probationary contract is in terms of extension. And before even we look at extension, we've said that, we've talked about that probationary contract should not be for more than 12 months. So ideally, what would happen, the Act mandates that the probationary contract should be for a period of 6 months. And if need be, if there is any need for extension of the probation contract, it can only be extended for a further 6 months and no more. So that brings the total to 12 months. Yeah. So the extension of a probation contract can only be extended to a further 6 months. So the probationary period can only be extended on grounds of non-performance or unsuitability of the employee for the job. Consultation must take place between the employer and the employee, and issues concerning warranting extensions should be discussed and agreed upon by the parties. As I've said, the contract can only be extended for a period of 6 months. So we look at a case here that touches on about extension of probationary contracts and what an employee should look out what an employer should look out for rather when they are extending a probationary contract. So according to that case, it was held by the court that the law requires an employer to confirm an employee upon satisfactory completion of the probation period. And if for any reason an employer requires more time to assess the performance of the employee, then the right thing to do is to formally extend the probation period for a specific period as provided under Section 42 of the Employment Act 2007. Once the probationary period lapses without any word from the employer is deemed to be confirmed by exclusion of time. So if you are you're an employer intending to extend the probationary period for a further period rather than the 6 months that you've already given your the person you had employed for on probationary terms, then the law mandates you must expressly put that down. You cannot assume. The extension cannot be done orally. You have to put that down in writing. There has to be a consultation where you inform the employee of your intention to extend the probationary contract. They must understand that, and then then you can proceed with the extension. But as I've said, the extension cannot be for more than 6 months. It should be 6 months or less. So when discussing probationary contracts, another issue to have in mind, important issue to have in mind, is the termination of this contract. So ideally, probationary contracts can be terminated by giving a 7-day notice. So either party can give a 7-day notice to the other if they intend to terminate the probationary contract, or pay the wages in lieu of notice for that period of time, for the 7 days. So there has been an issue that has been decided there's been an issue that has been decided with regards to termination of probationary contracts. When you look at the Employment Act, Section 42(1), it excludes the application of Section 41 to probationary contracts. Now, what does Section 41 mandate? Section 41 requires that an employer explains to an employee the reason for which the employer is considering terminating the employee on the grounds of misconduct, poor performance, or physical incapacity. So number one, Section 41 puts upon the employer, obligates the employer to give an explanation to an employee if they intend on terminating that relationship. Section 41 also prescribes the employee's right to have a shop floor representative at such time of such explanation. So the employee should have a person with them at the time that they are getting the explanation as to why the employment contract is coming to an end. Section 41 also goes along to give the right to the employee to make presentations based on the feedback that they are getting from the employer and why they are being terminated. But you'll notice that the Section 42 had said that these rights do not apply to probationary contracts. That is what the law had provided for. But we've seen now case law giving clarity to that provision and actually ousting the provision of Section 42 with the effect that you have to afford your employee those rights, even if you intend to terminate their probationary contract. Meaning, you have to afford them, you have to explain to them the reason why you are terminating them, even if they are on probation. They have to have a representative with them at the time you're giving them that explanation, and they will have the right to make representations based on their feedback or the information that you're giving them about why they are being terminated. So we have a case there of Monica Munira Kibichu and 6 others versus Mount Kenya University and the Attorney General, where you have these petitioners who are employed by the Mount Kenya universities under a probationary contract. They were given no explanation. After 3 months, they were terminated with no explanations. So the respondents in this case were trying to argue that Section 42(1) of the Employment Act allows them to terminate a probationary contract without necessarily affording those rights of a fair administrative procedure to the petitioners. But the court held Section 42(1) of the Employment Act to be unconstitutional, and it was ousted because, of course, the Constitution under Article 47 provides for the rights of a fair administrative action, which Section 42 was limiting. So in terms, there's that case which has now set the position right, so that even if you engage somebody on probationary contract, then it's your responsibility during the termination of that contract to ensure that you give them a proper hearing before you, and of course explain why you're terminating the employment and give them a fair procedure before you terminate their employment. So I've taken you through 3 types of employment contracts, contrasting them where applicable. I will now allow my colleague to explain on fixed term contracts and take you through the rest of the presentation. That would be my colleague, Simon.
Thank you, Susan. Simon, you can take over. You're on mute.
Yeah, thank you, Susan, for taking us through the first part of our training today on employment law and practice. Thank you, Rosario. Good morning, everybody. Welcome once again to our training. So I'll be taking you through fixed term contracts. The purpose for executive contracts and the scope to do with, the general employment contracts as well as consultancy agreements. So as we narrate the same to maybe your understanding, it is important to note that some of the aspects captured herein are important to also explain using case law and what the courts have, decided from time to time. So on fixed term contracts, you note that they are actually, by definition, they're determined by the actual end date specified in the particular contract. You find that fixed term contracts tend to range in terms of the applicability in businesses as to do with, say, when a certain operation is being undertaken. So they're mostly used by startups, for instance, whereby the certainty of future continuity of employment is somewhat not determined. So you have a fixed term contract maybe running for a specified period of time. And as per their definition, you tend to realize that they actually tend to end, or rather their expiry is determined by the end date specified in the specific contract. They can also be determined by factors such as the lapse of time, completion of a specific task that was assigned to by the employer, as well as the occurrence of a particular event. So noting the same, there is actually no need to provide a notice for termination, for instance, because once these particular aspects specified come to pass, you realize that the contract is automatically coming to an end. Nonetheless, it is also important to note that employers may not notify the employee of non-renewal. Yeah, and much as, yes, it could be based on the employer's performance, this is actually directly determined by the employer-employee relationship. So it basically determines, or rather is basically determined by what is stated in your contract. So if your employer provides that the contract, and this is express provision, that your contract will be renewed subject to your performance, it creates the idea of a legitimate expectation, which I'll be discussing in a few. And you note that since it's not subject to automatic renewal, the courts have been very vocal in terms of adjudication that has been brought forth, whereby an employee who feels like they ought to have had their contracts renewed brings the matter before court. For instance, in Rajab Baraza and others versus Kenya Meat Commission, the court held that in as much as term contracts cannot be renewed automatically, even when there is a specific clause in the agreement expressly stating that they can be renewed, this does not actually come into play. It is important to note that this legitimate expectation of renewal has no basis, as the employer, him or herself, has the utmost discretion to renew your contract or not. Also, much as the contract is not subject to automatic renewal, on the part of termination, it is also important for employers to note that much as, yes, the contract will be determined by the end date, where the employee maybe was assigned to a piece of work and it needed that they need to travel somewhere, if the contract comes to an end during this particular employee's travel period, it is important for the employer to note that the contract may be extended to cover for the period of time that this journey taken by the employee comes to an end. And also, most importantly, this period should not be for precisely more than a month, in order to have the flexibilities of not infringing on the employee's rights, and also maybe the employer not having that extended period of time to come to a conclusion on the contract. Also, in terms of the idea of legitimate expectation, much as the contract is not subject to automatic renewal, it is important to note that this is a general rule. And for any general rule, there has to be exceptions. So some of the exceptions to do with the legitimate expectation come to play whereby, say, the employer themselves made an ambiguous promise to renew the contract subject to, say, certain conditions, such as exemplary performance. And this was captured in the Teresa Carlo Omondi versus Transparency International. So in the matter, the employer directly provided that their contract for the employee may be renewed subject to their exemplary performance. If they do their work well, will be able to renew the contract. So the courts found that once this is expressly determined, the employer cannot go back on their word. Also, another exception is if the employer per se fails to make a certain act or decision in terms of the contract itself, or for instance, fails to do something or omits something that was, say, intended towards bringing the idea of continuity of the contract, then, for instance, such as ceasing payments, if the employer still pays you, the contract is somewhat creating that idea of a legitimate expectation that the contract is still on. Yeah. Even after the employment contract comes to an end, then the idea of the contract still, by virtue of payments still being made, the contract is still on. And in Cleopatra Kama Mugienyi versus AIDSPAN, the court was clear that there must be an indication in terms of the act or omission by the employer that forthcoming renewal was actually imminent, thereby creating that aspect and principle of legitimate expectation. Also, in terms of your engagement with your employer or the employer-employee relationship, where it is the usual, practice by the employer that they normally renew contracts even after the end of the fixed term, or it is actually expressly provided, then this actually tends to then create that aspect of legitimate expectation that the contract might still be on. Also, most importantly to note is that the idea of legitimate expectation should be differentiated per se between an anticipation or maybe the desire or the hope of the employee to have their contracts renewed. So much as, yes, you're expecting your contract to be renewed, the idea of you hoping for a renewal, of you anticipating a renewal, or your own desire for renewal by the employee in this instance doesn't create that idea of a legitimate expectation. So it's very important to note that aspect in order for you as an employee not to feel maybe disadvantaged if the contract doesn't maybe get renewed and you're still in employment. Also, lastly, to do with the idea of legitimate expectation, it's mostly important for the employer to have this expressly provided. So it mostly lies between the fair play of the legitimate engagement between an employer and an employee. Next, we come to the contracts to do with executive contracts. So executive contracts are the ones used by companies to hire high management individuals. So individuals involved in the day-to-day decision-making of the company. This has to do with people like the chief executive officers, the chief finance officer, the chief operating officers, and such. So executive contracts are mainly made by companies or organizations towards bringing these particular people on board. And since the idea is to have them in top management, the contracts tend to have some perks in terms of what they provide for in order to attract these high, individuals, high status individuals, perhaps, in order to run the organization. You've noticed that the CEO tends to be the key player in terms of running a particular organization. That's why even for the perks between, say, the CEO and maybe a director in terms of a particular department, the perks tend to be different. So they generally provide for the traditional clauses in any normal employment contract, but more to the traditional provisions, they also provide for special types of protections and perks afforded to this executive employee. And the special incentives tend to provide for aspects that, give them that sense of authority, or maybe differentiate them between the rest of the junior employees. So you find that in order for companies to bring these high-end individuals and such, their contracts tend to have special perks. So for instance, the contract of employment might state that they're providing maybe a vehicle, a special vehicle for the executive to for their transportation per se. Even in terms of their payment, these perks tend to be different. Also, the most important aspects to consider in terms of executive contracts are the clauses captured therein, whereby much as, yes, they capture the traditional clauses, some of the clauses tend to provide for maybe confidentiality and aspects of intellectual property. Remember, this is a high-end individual, an executive. And since there are sort of high demand for these particular individuals, other companies might try to poach them. Other companies might try to bring them on board, to offer these special services and skills that they actually have as executives. So in order for your company to protect itself against the change in terms of this particular executive leaving, the confidentiality clauses tend to be very strict in terms of what they entail and what's captured therein. Also, in terms of aspects to do with the change in control arrangements between the company and this specific executive, tend to be drafted in such a way that, much as these aspects of them leaving, say, this particular employment, aspects to do with severance pay, aspects to do with post-termination benefits, whilst also addressing the change in the company, are also very important. And this brings us to the idea of the malus and clawback clauses. So for the malus clauses, you find that as an executive, there are specific aspects of decision-making that they undertake. And these have a very high bearing effect in terms of running the company. So if this particular executive, for instance, does anything unethical, which tends to put the organization in a reputational crisis, or maybe financial decisions that have a very serious effect on the company, then the malus clauses come in to protect the company. Then on clawback clauses, if, say, this executive makes a decision that has far-bearing consequences, mostly negative, on the company, then the company can still recover in terms of maybe getting back, if it's payments that were made, they can also be able to recover in terms of getting back, maybe it's if it was remuneration that was done, if it was a benefit that was done. For instance, if the executive made a decision and the case, maybe the company was taken into court, and the court made a decision that there is need for compensation, so the company can go back to the executive and try to recover. Then also, lastly, in terms of the employment and consultancy contracts, there's the idea that consultancy agreements ideally are not really employment contracts. And in terms of the differences I'm about to share, you'll realize the same. So employment contracts are a special paradigm in itself, whilst consultancy agreements tend to be different, even in terms of their definitions. So you'll find employment contracts are mostly defined as contracts of service, while consultancy are determined as contracts for service. In terms of the engagements, employment contracts are between the employer and the employee, whilst consultancy agreements are between the client and the consultant. Also, employment contracts tend to encompass a broader scope of responsibility and offer a long-term commitment to the organization, whilst consultancy agreements tend to revolve around project-based assignment. Also, another difference is that the employer tends to provide the tools and determines the places and hours of work. So this comes into the idea of the job description. So the job description for an employer is totally determined by the employer themselves. But for consultants is they normally come with their own tools, and even in terms of the hours of work, they normally prefer this by themselves, unless maybe it's provided in terms of the employer-employee, or rather the client and consultant engagement. Also, the employee is subject to direct control of the employer. So this has to do with aspects, say, of dress code. The employer determines even the rules in terms of the engagement. They are normally determined by the employer. But for the consultants, they normally work without any direct supervision. So the consultant comes in, does their work, finishes, and leaves. But for the employment case, mostly you find it's between maybe 8 to 5 or 9 to 5, for instance. Then in terms of the remuneration you find for employment, there is regular salaries and wages, whilst for consultancy, remuneration tends to vary in terms of the services that they actually provide. Then in terms of the statutory deductions for employment, the employer themselves directs or maybe handles these deductions, such as the NSSF payments, the NHIF payments, the pay as you earn, and if, for instance, like in the recent developments, the housing levy, these are subject to the control of the employer. Whilst on the side of the consultant, they handle their own taxes, their own expenses, their own deductions to the Kenya Revenue Authority are determined by the consultants themselves. Then also, the employees are entitled to a range of benefits, maybe in terms of housing allowances, and this is normally captured in their contracts. Whilst for consultants, their perks in terms of allowances tend to be captured in their remuneration, and they also tend to handle their own expenses themselves. Then also, in terms of breach of the employer-employee relationship, this is handled by the Employment and Labor Relations Court, whilst for the consultancy agreement, it's done between the contracts, the aspect of the contracts come into play. So the contractual terms and aspects to do with contract law are determined by the courts directly. Then in terms of maybe understanding what the courts have provided between on aspects to do with consultancy and employment agreements, in order for the idea of differentiation between a consultancy agreement and an employment agreement, courts have developed tests that are usually used maybe individually or used all of them in one go in order to determine whether it's an employment contract or a consultancy agreement. In Christine Adot Lopeyo versus Wycliffe Mwathi Pere, the courts, the learned judge developed some of these particular tests in order to set out the differences. So in terms of the control test, the courts tend to look at how does the employee employment relationship work? If the control is subject to what the employer directly mandates the worker to do, then this is actually an employment contract. If this particular person does work under their own control, but still doing work for their contracting party, it comes into the aspect of a consultancy. Then also the integration test, you realize that in terms of the integration test, this is you're being integrated into the core practices of the company. So if you're under, say, the rules and procedures of the company, you're an employee. If you're free to do your work in your own style, come with your own tools, you feature as a consultant. Then the entrepreneurship test is mostly important in terms of determining the idea of risk and profit that comes back into the business. So if there's an aspect of you as the worker being directly involved, directly affected by whether the business is making a profit or a loss, you're under employment. But for consultancy, since they undertake most of the expenses on their own, you find that they are not directly affected by whether the company is making a loss or a profit. Then lastly, in terms of the mutuality of obligations between the contracting party and the contractor of the worker, whereby if one makes a commitment to maintain the employment relationship over a period of time, mostly this has to do with the employment aspect. But where the aspects of coming into work are not directly forming part and parcel of the business itself, or in terms of maybe the decision making, in terms of the obligations this particular person has to undertake, they fall under the idea of a consultancy agreement. So that is all to do in terms of the idea of fixed contracts, executive contracts, and employment agreements, as well as consultancy agreements. My colleague will take the next aspect to do with the following aspects in terms of our training.
Thank you, Simon. I'll proceed to take us through the basic working conditions for employees, and this will basically be oscillating around the leave days, so annual leave, maternity leave, paternity leave. There's also a new introduction of pre-adoptive leave, sick leave, when should salary be paid, and then what statutory deductions should you be making and at what point. So we can start off with working hours. What working hours do employees have and when can they take leave? So employees are entitled to at least one rest day for every period of 7 days, and they're entitled to 21 leave days, which is normally calculated at 1.75 days per month. Now, the Employment Act does state that the employee should have at least 2 uninterrupted working weeks of leave days, and then the remainder to be taken within 18 months from the end of the earning period. However, it's important for businesses because the law says, unless otherwise provided by the company or by regulations, it's important for companies to ensure that they have a HR policy on how leave days could be taken, so that this can be the foundational document of how leave days are to be utilized. So on utilization of leave days, we can look at a number of cases just to see what issues arise in court and where you can be able to protect yourself as a business. So in a case, it was held that the employee has a right to take annual leave, and it's the duty of the employer to ensure that the employee has taken annual leave as and when due. So the issue of forfeiting leave days is also not protected by the law. And if the employee actually does not take leave days, and as you can see, the courts have put the mandate on the employer to ensure that the employee takes leave days. If the employee doesn't take those leave days, then those leave days should not be forfeited. And in the event of termination, then they should be compensated. It becomes like an accrued benefit, which should be monetized and paid to the employee. So it's important to ensure that the employees take the leave days. Otherwise, then it becomes an accrued benefit. Now let's move to maternity leave. Now, maternity leave are for female employees, and they are entitled to 3 months maternity leave with full pay. On the expiry of maternity leave or during the period when they're pregnant, they have a right to return to the job that they were immediately prior, or on reasonably suitably conditions that are not less favorable. So you can bring them back to a lower position that they were before just because they've gone on maternity leave, and this counts as discrimination. We look at a case that talks about discrimination and the kind of penalties that you'll be subjecting yourself to if you if you end up giving someone less conditions just because they went on maternity leave. Then the notice period required for the maternity leave, for you to take a maternity leave as provided by the Act, is 7 days notice. Now, this may not give an employer adequate time for them to get somebody to replace them during the period that they've been on maternity leave. So again, it's advisable for you to have a policy on how soon the employee should give their notice. So it could be 3 months to taking the leave or whatever you provide, so that you can provide yourself with an ample amount of time for you to be able to get your house in order. However, it's also important to note that sometimes things don't go as planned, and so the rules shouldn't be cast on stone, in that you should provide for an opportunity for the employee to still be able to give notice if an emergency happens, for example. So for example, if they're supposed to give notice a month to, and then the baby comes 5 weeks to, it shouldn't be that they now lose the opportunity to get maternity leave. You should put an option for them to give their notice as long as they have proof. But it's important to have this policy so that you can provide for that criteria, and you don't end up creating a situation where you have discriminated someone because they're taking maternity leave. So we can look at a case, Mokaya versus Kithure Kindiki. You'll be surprised because this is a law firm, so you understand that nobody's above the law. And so what happened in this case is she got pregnant and applied for maternity leave. It was approved. Then the employer decided, actually, no, refused to approve the leave later on, and started requesting the employee to take leave, but without the benefits. So maternity leave is to have paid leave. So they were asking the employee not to take paid leave. The employee refused to sign the documents that they were requesting them to sign. So what happened is she was later terminated, and she went to court to sue, and she ended up getting a total of 2.2 million, being 6 months salary, which was for unfair termination. She also got salary for a year notice because they didn't give her notice for the termination, and for leave days, and 1.5 million for violation of their rights, for basically discriminating her because she was pregnant, because the reason they were giving is that the company did not have, they were facing financial constraints, so they were not able to keep paying her. But if you look at the sequence of events, it was obvious that the reason that they had terminated her was because she was taking maternity leave. So it's very important to ensure that businesses protect themselves and are also not discriminating employees because of matters like employment. The next one we shall address is paternity leave. So employees are entitled to 2 weeks paternity leave with full pay. Most of the issues that arise with this is on termination. Employees will normally say that they applied for paternity leave and they were not approved. So like this case, they hadn't given evidence that they were going on paternity leave or given notice that they need to go on paternity leave. So again, it's important to state in the policy at what point the notice should be given, so that you don't end up having this sort of issues in the organization. Now, pre-adoptive leave was introduced in the Children's Act, where an employee is entitled to 1 month's pre-adoptive leave with full pay from the date of the placement of the child. Now, for this, you will need to provide a certificate from the Adoption Society for you to be sorry about that. You need to be given an adoption certificate for you to be entitled to get the pre-adoptive leave. Then you also need to give notice, and the Act provides for at least 14 days notice. But like I said before, it's important for the businesses to ensure that they have a policy to state how long of a notice you need employees to give, because in as much as the Act provides for this notice period, it may not be ample time for your business to replace the employee. So ensure that if you don't want to give what is given in the Act, which is 7 days, or like this one, 14 days, ensure that in the policy you provide the notice period for taking leave. Now, sick leave. The Act provides for 7 days with full pay and after 7 days with half pay. But as you can see here, it says not less than. So you could always give more than the prescribed amount of period. However, it's also important to note that in the general wages order, employees are given 30 days with full pay, and thereafter 15 days with half pay. So you can see that the wages order is more favorable than what the Act provides. And what the Act states is if there's another regulation that provides for better terms, then that should be the statute that is used to so basically it would be advisable to use what is provided in the regulation, which is a 30 days notice, that the 30 days sick leave, and thereafter 15 days with half pay. Now, what happens when an employee is sick for a long period and is unable to continue acting? Are you allowed to fire them? Now, we'll talk about termination later, but I can just mention this in passing, is that for you to terminate an employee on account of sickness, you need to have met specific criteria. Otherwise, again, you will be held to have terminated someone unfairly. So the law does state that you need to ensure that you exercise due care and sensitivity before before terminating someone on account of sickness. And first, that you as an employer must show support to the employee to recover and resume duty. Now, again, this may be taken subjectively, but you need to ensure that you have taken all measures to ensure that you have supported the employee. Secondly, you need to ensure that you take a specific medical examination, and taking the sick-off notes and the treatment notes don't serve as a medical report. You need to do a specific medical examination to state that the employee is physically incapacitated and is unable to continue working in the organization. And then third, you must give the employee specific notice of the termination, and failure to follow this, of course, will just note that you've not given enough evidence of the employee's inability to work, and it amounts to unfair termination. So it's important to note that when it's on account of sickness or physical incapacity, you also need to follow a specific procedure. Otherwise, again, it counts as unfair practice. Now we're done with the leave days. Let's talk about salary payment. Salary actually needs to be paid not later than 9 working days after the end of the month. So the 9th day of the next month, the salary should have been paid. It's also important to note that employers are also supposed to provide reasonable housing accommodation for each of their employees, or to pay a housing allowance in addition to the salary that you're paying. Now, it doesn't apply to the employees whose contracts provide for that the housing has been provided in the salary. So it is very important to ensure that if the salary contains housing allowance, that is provided in the contract. Otherwise, it will be held that you are not providing housing, and an employee could always come back and say that you're not giving them housing, and they could go to court, and because it's not provided in the contract, again, you will have to pay them an extra for housing. So if housing is covered in the salary, it needs to be noted in the contract. Now let's move to the statutory deductions. What is payable and when? So NHIF, which is health, needs to be paid. This will be replaced with SHIF tentatively from July. We shall note to update this once we have further updates, but for now, NHIF needs to be paid. And then you also have NSSF. So there's a new schedule for NSSF that also needs to be paid. Then there's the housing levy. The bill was assented to on 19. So from March, we expect that we will be getting houses. On a lighter note, no, you will be paying the housing levy from March. And then we have NITA. So NITA is the training authority, and employers are expected to remit 50 shillings per employee per month to NITA. So if you know you have an employee, you need to be remitting 50 shillings per employee per month. Now, I know many businesses don't do this, but KRA has actually started sending notices out to employers, and there's actually a penalty for non-payment. So if they decide to look at the penalties that you've not paid, you could also be liable to a lump sum of payment. So it's important to ensure that you remit 50 shillings per employee per month. Then it's also important to note if you have apprentices or interns, industrial attaches, or if you're conducting training as a business, you need to have approvals from NITA. For more information on this, you can contact us. But it's important to note employers, you're expected to remit 50 shillings per employee per month. If you have any questions, please leave them in the question box so that you can be able to address them. I'll now ask Sarah and Washera to take over so that they can take us through the duties of employment of employers. Sarah, Washera.
Thank you, Rosario. As has been stated, my name is Sarah Akinyi, and I will be taking you through the first part on the duties of employers. So, as with any given relationship, parties are required to fulfill certain obligations, and in an employment relationship, an employer is required to fulfill certain duties towards the employees. And the first point will be employers are required to afford all employees equal opportunity in employment and ensure that discrimination is not tolerated in the employment policy or within the particular practice. And to illustrate this point, there is a case here of LC versus Sotic Tea Company Limited, where the claimant, who was an employee, was terminated on account of ability. So the employer was of the opinion that she was incapable of diligently performing her duties. So that was reason enough to terminate her services. However, the court found this to be a discriminatory ground because the employee had taken all steps to ensure that she would be able to offer us her services adequately. She was able to learn how to read using Braille, and she was also able to learn how to use walking using a white cane. But the employer did not deem this enough. So the court awarded her 2 million shillings as general damages for the discrimination. The second point is on every employee is required to be paid equal remuneration for the work of equal value, regardless of age, race, or color. And an example would be where an employer has 2 or more secretaries. The employer needs to ensure that they are all paid the same allowance, they are all afforded the same benefits, where there's medical insurance to be provided for. Everyone in the same category should be provided for in equal terms. Our next point will be touching on writing up appropriate contracts, and this has been already very well elaborated by Susan and Simon, where they talked to providing written contracts, they spoke to probationary contracts, they spoke to casual employment. And you see here, there's an additional point where as you're drawing these appropriate contracts, you need to ensure that they're appropriate for each type of employee, considering those that may be impaired. So if you happen to have somebody, let's say, who is visually impaired in your employee, you need to ensure that the contract is provided for in Braille so that they can be able to understand the terms of their contract. The other point is on an employee needs to be well informed of their rights by displaying this in a conspicuous space that is accessible to all. So informing employees of their rights can be in the form of having a human resource policy, which will be touched on in the next presentation. When you outline these policies, you're able to outline perhaps their code of conduct, how they're supposed to go about their daily operations, what is expected of them, and ensure it's accessible, whether it's putting the human resource policy in a open place where anybody can come and access the policy, or leaving it to the human resource officer, or placing it in a shared folder where anybody is able to access the said policy at any given time. The third point is on ensuring that you pay the entire amount of wages earned or payable to an employee in respect of work done and in pursuance of their contract. Now, this point will be illustrated by the case of Beatrice Wamboi versus Export Processing Zone Authority. In this case, Ms. Beatrice was interdicted for a period of 3 months. That means she was temporarily relieved of her duties. But during this period, she was still expected to show up to work on certain days. But in this time period, regardless of that requirement, she failed to report to work when she was required to do so. So the employer decided to withhold her salary. But upon further inspection, it was discovered that Ms. Beatrice would always provide reasons as to why she was absent. The employer was aware of these reasons, and the employer never disputed her leave of absence. So the employer was then found to be on the wrong and was ordered to pay her full salary with immediate effect. Another duty that you are required to extend towards your employee. Just give me a minute. You need to ensure that the wages are paid in the following manner. You need to ensure, number one, that it is paid on a working day. 2, that it is paid during working hours. Number 3, that the wages are paid at or near the place of employment or any other place that you and your employee agree upon. Just ensure that where this place you've agreed to meet and exchange payment, it should not be a place where intoxicating liquor is sold or readily available, unless, of course, the employee happens to work there. Another duty is on applicable deductions, which Rosario has discussed. So you need to, as an employer, you need to ensure that you remit the applicable deductions depending on the contractual agreement and laws governing the same. And we have a case here of Nicodemus Ochieng versus Village of Hope. So in this matter, Nicodemus was claiming non-remittance of NHIF and NSSF deductions. So the employer used to make these deductions, but he never remitted them to the relevant statutory bodies. So as a remedy, the employer was instructed to refund the said deductions to the employee with interest. Another duty would be to ensure that an employee has received a written statement at or before the time of payment of wages is made together with the statutory deductions. So as you're paying your employee their wages or their salary, ensure that you have a receipt that is written and it appropriately outlines what the employee has earned during the employee. And we have a case here of Peter Wafula Wasike versus Lockwood Girls. So Peter Wafula was employed as a principal for a certain high school, that is Lockwood Girls, but his employee was terminated. So he took the matter to court on grounds of unfair termination, and among the things he was seeking was salary arrears to the tune of 587,926. So the employer disputed this figure, and what did they do? They provided M-Pesa statements. But you see, an M-Pesa statement doesn't outline what the employee has earned during the contract of service. So due to this absence, the Mr. Peter, who was the high school principal, he was awarded the amount that he was seeking. And just to drive this point home, there's another case where it was still on issuance of a written statement in Alphonse Mua Kasimu versus Electrical Card Services. The judge said a payslip or a salary voucher evidences payment of salary, and an employer who fails to provide it cannot rely on its absence to defeat an employee's case. So just because something does not exist does not mean that you can get away with it. So you should take note of that particular duty, and Washira will pick up from there.
Right. Thank you so much, Sarah. So I'll take us through more duties and responsibilities that employers have towards their employees. For starters, it's to give notice to the Ministry of Labor at the instance of death of an employee, but there's also other instances according to the Employment Act that you're required to give a notice to the district commissioner or labor officer. For instance, is the employment contract, you need to give the terms and conditions for employment. If there is an instance of termination of employment, if you're employing foreign nationals, you need to give specific details. That's the nationality, qualifications, and the terms of the employment, as well as any changes in working conditions, such as working hours, benefits that you may be applying to certain employees, or you may be deducting certain statutory deductions as required. Also, if there's any industrial disputes, for example, strikes, lockouts, or any other action that could be referred to the labor court, this has to be reported in most instances first to the ministry or the district commissioner, as well as any workplace accidents or incidents that happen during time or period of employment, as well as employment of minors. There are instances where you'll find, for example, like in the advertising industry, where minors are contracted or taken up as employees, of course, under the requirement guidance. This needs to be reported to the ministry because there are laws and regulations that guide child labor activities. And there's also collective bargaining agreements. So these are basically agreements that come into place, not just through the employees directly, but through, for example, bodies like trade unions. So this is what we call collective bargaining agreements. These also need to be notified to the Ministry of Labor. Other than those notices, we also have other acts that provide for duties and responsibilities that an employer has towards the employee. And for example, I'll touch on the Data Protection Act, more specifically on how an employer needs to be handling an employee's data. And this mostly circumvents around human resources. So it's in the data that you collect, exactly what you need to be collecting, how you're going to process this data. Your employees need to have this information. There's also need for consent to be taken from your employees in collecting and processing of this data, how long you're keeping this data for, what you're using this data for, and also to ensure that you're only collecting what is necessary. You might find that you need specific information for things such as insurance policies, insurance covers, information such as next of kin information in the event of emergencies, medical records. It must be articulated how you're going to collect, process this data. Employees must be sensitized on how this data is being kept, and even at the point of termination of employment, how long after are you keeping this information for, and what ways are you discarding the information? Is it as directed by law in the first instance? And are you also making your data subjects aware of everything, third parties that you're sharing this information with? Next. Yes, there's also a need to have data protection impact assessments done constantly to ensure that you're within the regulations set by the Data Protection Act and regulations. And in the instance of a breach, you have to notify your employees without any delay that there's personal data that has been leaked or has been accessed by unauthorized parties, and that these measures being put in place to either recover or to inhibit any further interference of their personal data. There are also instances where you find as a company, you might need to have a data protection officer because of the amount of data that you're constantly handling at a go. A data protection officer could be in-house or could be on consultancy basis. That is, of course, left to your discretion, but depending on how much data and information that you use, mostly it's preferable to have in-house data protection officers. Moving forward, we have the Work Injury Benefits Act that focuses on specific duties and responsibilities when it comes to work-related injuries or occupational diseases. For example, those running factories, those running construction sites, etc., etc., it is your duty to register and comply to NHIF, NSSF, and now SHIF. Also, you need to give your employees proper information under this particular act on what is required of them, what is required of you, their rights, and also any other factors that you think that are set there and are necessary. You also need to provide safety and health measures within the work environment. You also need to ensure that there's insurance coverage. Of course, this is negotiated for in your contract. And as a general rule of thumb is that you need to keep record of any injuries that happen during the working period or within the area of employment, and any record of insurance covers that have been taken, and also the usage, while still complying to the Data Protection Act. So when it comes to housing, to simply put it, when you're bargaining or when you're negotiating a contract with an employee, you need to ensure that you consider, in terms of wages paid, you need to consider housing, reasonable housing accommodation. If you're not providing physical house, you need to ensure that what you pay your employee is reasonable enough to cater for them to be able to pay for a rental space. And as in this case, for Green Pro Kenya Limited versus Andrew Waithaka Kiragu, in this particular case, there was an account of unfair termination, and part of the damages being sought by the employee who was terminated unfairly was that of housing allowance. And the Act did not indicate specifically whether the salary included house allowance, but it indicated that there were other benefits as required by law. Therefore, the court held that since the contract was not very specific on the provision of house allowance, then it meant that the employer was liable to pay the employee house allowance. This might come off as such a general rule, but it is within the law that in the workspace, you need to provide for safe water, safe drinking water, water to wash your hands, but also in the event where you're providing housing accommodation, this is also required by law that you have safe water available to your employees, and that also there's sufficient provision of proper medicine for employees during work hours, and if possible, medical attendance when there's an instance of serious illness. So for this, I would possibly give an example of first aid kit, having first aid warriors in the office that can help deal with emergencies before further care arrives. Other duties and responsibilities that employers have towards their employees is that there are mandatory policies and that those that are also recommended for you to have. For example, there's a sexual harassment policy, and this comes into place where you have 20 or more employees as per the Employment Act. However, it does not mean that just because you have less than 20 employees, you don't need to have, it's recommended as well to have a sexual harassment policy. You need to have a policy against discrimination, as my colleagues have mentioned, the grounds for discrimination, an anti-bribery policy. I think when you go to most government institutions, you will see those notices saying that this is a corruption-free zone. You might not necessarily think that is a policy, but there's backing behind that kind of notice. Another mandatory policy is a data protection policy if you're a data controller, a processor, and it's good to note that it is very possible to be a controller and a processor. And in actual fact, in most cases, controllers do double as processors actually. As well as other recommended policies like the human resource policy, policy on leave, as Rosario has mentioned, terms of leave, code of conduct, non-compete policies in terms of restraint of trade. Thank you.
Thank you, Washera. Emily will take us through termination. So if you can just pay attention for this because it's a very important element. So Emily, you can take it away.
Thank you, Washera. Thank you, Rosario. This part of our presentation will deal with termination of employment, aside from the other factors or instances under which an employer or employee may decide to terminate employment, which my colleagues have dealt with, say, for example, physical or mental incapacitation. This part of our presentation will deal with the expiry of the contract period, termination on notice, summary dismissal, as well as redundancy. So with regard to expiry of contract period, this applies when the contract entered into between the employer and the employee is a fixed term contract. So which may provide that this contract is only going for a period of 6 months. And once the 6 months are over, then automatically the contract expires. In the case of Transparency International Kenya versus Teresa Carlo Omondi, the court held that the employer doesn't have to give another reason for terminating that fixed term contract apart from the lapse of time or the term has expired. However, I'd like to caution people who are used to repeated renewals of the contracts, like after the 6 months, you go on a 1 month break, then you come in again, we renew it again for 6 months. It may create a situation where the employee can be able to claim legitimate expectation. The second part, we're going to deal with termination on notice. So depending with the contract entered into between the employer and the employee, it should stipulate the notice period to be issued. However, in absence of that clause in the agreement, we are guided by the provisions of the Employment Act, and for a term contract of 30 days, the employer or the employee, whoever chooses to terminate the employment relationship, should issue 30 days notice or make payment in lieu of notice. Payment in lieu of notice. So if I'm supposed to give a 30 days notice and I don't issue that, I should give my employer money equivalent to what I would have earned within that 30 days period. And the employer is required to give reason as to why they decided to terminate this contract. In the case of Kenneth Onyalo versus Majnis Resort Lamu, trading as Majnis Lamu Limited, the court stated that the employer must justify a termination of a contract of service by providing reasons for the decision, and no such obligation exists as against an employee. So all the law requires is for the employee terminating the contract to issue the employer with the requisite notice to terminate, or to pay the employer or to pay the employee an amount. Sorry, if it's the employee terminating, they should give requisite notice to the employer. And if they don't do that, then they should pay the employer an amount equivalent to the notice period that they should have given notice. So we head to the second part where we are going to talk about summary dismissal. So summary dismissal occurs where there is termination without notice or less notice than that to which the employee is entitled to by statute or by contract. Before I proceed, I'd like to state that we have people who provide that we are not going to give the 30 days notice period, we're going to give the 45 days notice period. So if such a matter of unfair termination goes to court, we are going to follow what's in the contract so long as it's beneficial to the employee. So summary dismissal is termination without notice or less notice than that to which the employee is entitled to by statute, which is the Employment Act or the contract they have entered into. So for you to claim summary dismissal successfully without having a claim of unfair termination against the employer in court, you have to ensure substantive and procedural fairness. We are going to look at this next. So among the reasons why an employer may choose to summarily dismiss an employee include absenteeism without leave or other lawful cause, intoxication during working hours, rendering the employee unwilling or incapable to perform their duties, and willful neglect to perform any work which was their duty to perform, insubordination, use of abusive or insulting language or behaving in a manner insulting to the employer, and where the employee is arrested for a cognizable offense punishable by imprisonment and is not released on bail or on bond or otherwise set free or at liberty within 14 days. The other reason may be the employee commits or on reasonable and sufficient grounds is suspected to have committed a criminal offense to the detriment of the employer or the employee's property. So the procedure, the employer should issue a letter to show cause informing the employee of the wrongdoing. Next, they should invite them to a disciplinary hearing, and this will provide them the opportunity to be heard. And in this instance, the employee is entitled to have a fellow employee present, or if they are a member of a trade union, then a union member should be present. Then during the disciplinary hearing, the parties should hear and consider any representations that have been made by the employee and the person chosen by the employee to represent them. And then now they should render a decision in writing after considering the representations made. So again, if this procedure is not followed, the employer may find themselves on the wrong side of the law, where they'll be informed that the court will decide that they have unfairly terminated the employee. Case in point, we have Phoebe Alo versus Stockwell, One Homes Management Limited. The claimant was employed as a cleaner, and one day she went to her working space or the working office, and she found that the door was locked. Upon inquiry, she was told that she had been dismissed because she was being rude. And that was it. So she was told, come the next week, come collect the dues that we owe you. So she went to court, and the employer was trying to defend themselves by saying that this is not the first time she has been rude. This was a repeat offense. But then they didn't give them the chance in both instances to hear them out, to defend themselves, to come with a representative, all that. So the court held without a requirement for a representation, one cannot be said to have been allowed an opportunity to be heard. So what happened was that the court awarded her 5 months gross pay, a gratuity amount at the discretion of the court, and she was supposed to be paid her prorated leave pay and interest from the day the suit was filed until full payment was made. On the contrary, we have a case where summary dismissal was upheld by the court in the case of Kenneth Mutinda Mbidi versus Simba Hospitality Services Limited, where the claimant was accused of sexual harassment among other wrongdoings, but this was the main one. The employer issued him with a letter to show cause and asked him to respond in writing. So in the letter to show cause, they were telling them, on this date, someone made a complaint that this is what you did, you touched someone indecently. On this other date, a similar allegation was made, all that. So they were asked to respond in writing, in which he did. He was then suspended from employment to give chance for disciplinary investigation. Once they were concluded, he was informed that he should present himself for oral hearing, and he had the choice to come with a representative. So he appeared before the employer's disciplinary committee, and the decision that was made was that he should be terminated summarily because he had been found guilty of sexual harassment. He then decided to sue for unfair termination, but the court held that the termination was not unfair because in terms of substance, the reason for which he was being summarily dismissed was there and the procedure was followed. So we'll head to the next part where we'll be talking about redundancy. And redundancy is the loss of employment through no fault of the employee. Instances under which redundancy may occur is when the services of the employee or the position is superfluous and where there is abolition of office. So for example, where we have a law firm may be dealing with, we have a tax department, but then we now decide, the management decides we no longer want to have a tax department because we're not doing well or for whatever reason. So, and they decide to abolish that office. So in that instance, we may state that that position has been declared redundant. So for you to claim redundancy, the reason which you'll be advancing should be real and not cosmetic. So in the case of Daniel Mboro versus Hygrotech East Africa, he was declared redundant for reasons of financial difficulty. The employer was undergoing financial difficulties. However, the employer did not provide any financial or audited statements to show that, yeah, indeed, these are our statements for the previous 3 years or previous 2 months, we've been making losses, and so we've decided to render your position redundant in a bid to operationalize our activities or even sustain the business. So the court held that the reason should be real and not cosmetic. The procedure, one, where the employer should issue general notices. So where the employee is a member of a trade union, the general notice should be issued to the trade union and to the labor office of the area to which the employer or the employer's offices are located. And where the employee is not a member of the trade union, the general notice should be served to the employee and again to the labor offices. So what are the contents of the general notice? It should be a general communication notifying them of intended redundancy, the reason, and the extent. And this should be done 30 days before the date of termination. The next thing is consultation. However, we must know that it is not a requirement under the Act. However, it is a requirement under the ILO convention in which Kenya is a state party. And also in the case of Kenya Airways Limited versus Aviation and Allied Workers Union Kenya, it was held that consultation is implicit under the principle of fair play. So again, this consultation should not be cosmetic. It should not be assured where I am just consulting you and I already know this whole department is going, or I am already consulting you, but I have already decided Rosario is going or whoever is leaving, I am declaring that position redundant and all that. It is this general notice that will lead to the consultation and then lead us to the next point of selection of employees whose positions are to be declared redundant. So the criteria set in law is the SSAR test, which is seniority in time. And seniority in time, we look at the last employee who came in should be the first one out. So seniority in time, also we look at the skill the ability and reliability of each employee. All these factors should be considered holistically and a rated score assigned considering all the factors, so that we can state that Emily scored 5 and Rosario scored 10. So I will declare Emily's position redundant because she scored lower than the other people who've been left. Then the next one, the employer should issue a 30-day notice to the selected employees, and also if he's not given the 30-day notice, he or she should pay the 30 days payment in lieu of notice or the wages. Then the next step would be the remittance of dues, any unpaid arrears, and also to give severance pay. Severance pay is paid at a rate of not less than 15 days pay for each completed year of service. So if I worked for 4 years, then that's 15 days multiplied by the 4 years that I worked, and then you should pay me that. We'll head to the general duties, which employers or employees should know that upon termination, the employer should issue a certificate of service, except where the employment has continued for less than 4 consecutive weeks. So this is mandatory. It doesn't matter your relationship within the period of the employment. Next, they should pay unutilized leave days. Rosario, I think, talked about the issue of leave days. So if you consider terminating anyone and they had 4 unutilized leave days, they should be paid for that. Payment in lieu of notice, that is, if you're not giving the requisite notice, you should consider paying them in lieu of notice, and then you should pay any arrears of the salary. The payment of service pay, my colleague talked about the statutory deductions. So if where a member or an employee was not a member of NSSF or any pension or security scheme, and not just being a member, if the employer was not regularly remitting the contributions that are required to be made, then the employer is liable to pay service pay for that. We have a case of Elijah Kipkoros Tanui versus Ngari Opticians, where the failure of the employee to remit the monthly contributions on a regular basis, it was held that basic membership to a national security fund or other schemes is not itself a bar to the employee accessing service pay. Having identified that in most instances that the law is pro-employee, all is not lost. How do you protect yourself as an employer? One, as my colleagues have emphasized now time and time again, maintaining written contracts. Again, you have to remember that once the employee takes you to court as an employer, their work is just to state, like, I was employed here, I was earning 200,000, but maybe on the ground he was earning 30,000. But then because there is no written contract, it's for you to justify that it was not 300,000, it's 30,000. So maintaining written contracts and also proper record keeping. So if you go to court and I'm claiming 20 leave days, you should pay me for 20 leave days. How do you prove that I had already taken 10 and you only owe me for 10? So proper record keeping. The next thing is review of agreements, of the employment agreements and human resource manuals, and especially now where we have changes occurring now and then, amendments, new statutory deductions. It is important for you as an employer to review the agreements, the employment agreements that you have issued to your employees, so that you can bring them up to speed, so that if you note there's a clause you needed to insert, please do that. And also the human resource manuals, which will provide even for the disciplinary procedure, so that if you have not provided for a disciplinary committee and you want to summarily dismiss someone, you can breach that. Then you should also provide for the return of documents and equipment in the employment clauses, like if as a result of termination or I'm leaving employment with the employer, I should return the documents and equipment for which they had issued me to work. Then you should consider as an employer taking insurance covers for the executive officers, and also you also need some protective clauses in the employment agreement, such as intellectual property clause stating that any intellectual property developed by yourself in the course of working for me, it belongs to me, so that in case of anything, we are not here arguing. The agreement is very clear. The non-disclosure agreements to protect your confidential information about your suppliers, business partners, investments, all that, and also we can have restrictive covenants such as non-solicitation, so that once I leave, let's say I am in a law firm, once I leave, I go form my own law firm, I cannot come in and solicit my colleagues who I was working with to come work for me now or work with me. And also the non-compete clause, where you can restrict the employee upon termination from maybe starting the same business or a business that would compete with what you do primarily, and also the location. So like you can only do whatever I was doing in the course of my employment, but in Mandera and not in Nairobi and all that. So ladies and gentlemen, having discussed the types of employment, distinguishing between employment and consultancy, and the particulars, basic employment conditions, the duties of employers, termination and protections available to employers, we've come to the end of our webinar. This is the very first part of our webinar, but we could take questions. So I think I'll hand over this part to my colleague. Thank you very much.
Thank you, Susan. Thank you, Washera. Thank you, Sarah. Thank you, Simon. Thank you, Emily. Now,
Rosario, if you could, if you're able to read the questions that we have.
Yes. I'm reading the questions. So the first one, Susan, if you can take this. For interns, is it good practice if an employer decides to onboard them to subject them to probation? Is a 3 months or 6 months internship and confirmation as an employee enough? Susan, if you can take that, just answer that, and then we'll be going through the rest. Susan, are you able to take that?
Rosario,
Yes,
you can hear me?
Rosario, I am here.
Okay.
So you have to understand, first of all, what an internship contract, an internship contract is, and you will find that the Employment Act defines it as a contract for an indentured learner. And how it treats it, it treats it as a normal employment contract. And there's also been case law to back that position, that an internship contract should be treated with all intents as any other employment contract. So it is possible that
I can see a question that I could respond before Rosario confirms whether she's able to proceed with that. Bernard Kariuki asked what are the consequences of an employee leaving employment without notice soon after receiving their salary? So the duty to issue notice goes both ways. As I have said, it goes, the employer and the employee should consider issuing notice. So if an employee leaves employment without notice, as the employer, you can follow them for the 1 month. If the notice period was 30 days, you could follow them for the 30 days payment in lieu of notice. Or you could just choose to forgive them.
Yeah, I think I'll go back to the first question that was asked with regards to the contract of internship and whether an internship could be placed on probation. Just as I had explained, it is a contract of an internship contract by all intents of the Employment Act is taken to be like any other employment contract, and therefore probation can be applied to an internship contract, so long as the rules of a probational contract will also apply to an internship contract. You have to remember that you have to expressly set out that it is the internship, you'll be on internship, but with a probation period of a certain amount of days. Then of course it should not be more than 6 months. The probation period, and if it's extended, should not be extended for more than a further 6 months. So yes, it is possible to have that intersectionality between a probation period being contained within an internship contract, because again, as I've explained, the courts have found that an internship contract is basically similar, or it's the same thing as an employment contract.
Thank you, Susan. We can move to the next question. Housing levy, I think this was answered. So the act was assented to and is to commence upon assenting. So yes, from this month there should be deductions. So the answer is yes. And then there's another question: at what point will a contractor on contractual terms be deemed to be an employee, and what is the threshold on this? At what point will a contractor on contractual terms be deemed to be an employee, and what's the threshold on this? Simon and Susan, if one of you could take this, we can come back to it. The other question is, was the Employment Act repealed on sick leave from 30 days to 14 days? So the Act as it stands provides for 7 days paid leave and 7 days unpaid leave. Now, this is just the Act, but what we had mentioned before is that the regulations provide for 30 days. And so the regulations provide for a longer period, which is more favorable. And what we advise businesses is to give the more favorable terms, which is what is provided in the Act, that if there are more favorable terms, you give the favorable terms. Because even when we've come to look at case law, if you ever end up in a suit, the courts will look at what you did, like we mentioned in that case, to support this person. And so if there are more favorable terms and you're talking of 7 leave days, and you have the option to give them 30 leave days, you would rather give them a more favorable term. But that's what is the difference with the 30 days and the 14 days between the two regulations. Simon, are you able to take the question on contractors? Proceed.
Yes, Rosario, I'm able to proceed with that question. So on the aspect of whether a contractor on contractual terms may be deemed as an employee, actually, for instance, if this aspect were to go into litigation, the court would actually then look into the substance of the contract between these two persons. So you'd find the court generally would also bring in the tests for determination of whether a person is an employee or a consultant. So in this instance, once again, the court will tend to look at aspects such as control over this particular person, whether the employer or the contracting party has effective control as to, say, how the work is done, maybe their reporting hours, in terms to do with their dress code, for instance, even the job description itself. Does it go into the substance of trying to control or maybe command this particular person? It will also go into the aspect of, has this person been really integrated into the business in terms of, are they subject to the actual rules and procedures of the company, such as in terms of maybe even the dress code is actually a rule in itself. So are they subject to wear in a certain manner, maybe show up on Monday with a white shirt, maybe a black trouser or what have you? Are they subject to certain internal procedures of the particular company? Also, the court will look at the aspect of entrepreneurship, the entrepreneurship test, or rather the test for economic and business reality. So in terms of profits and losses, yes, both employee and consultants are affected by whether the business is making a profit or a loss. But ideally, you'd find for employees, they would be acutely affected, given that their pay is determined on whether the company is making some money or not. And also on the aspect of a consultancy, you find that aspects such as their taxes, their expenses are not affected. So looking at the same side on the employee, you'll find maybe their wages are not paid, their statutory deductions have not been captured. So if you're in either a scope and you're a consultant and your statutory deductions, you handle them, you're on your own and are not affected, of course, that will be deemed as a consultant. But if you're an employee and you realize your employer is maybe struggling, you'll deem yourself under an employment contract. And lastly, the court will also bring in the mutuality of obligation tests, whereby the court tends to look at, in terms of the reality between the contracting parties, whether there is the intention of the parties in terms of their contract. Are you working for me in terms of you're expecting a monthly wage or remuneration from my end? So in such an important to note that where the parties have made commitments to each other and you've been acutely ingrained in terms of there is a legitimate expectation from each side, that places you under an employment relationship. But if it's you've done your work, but you're not really mutually affecting the business, whereby you can make your own money on the side and still maybe depend on this particular person to pay you, and they fail to, then the aspect of mutuality is somewhat lost, and therefore you fall as a consultant. Thank you.
Thank you, Simon. Thank you for that. If you have any questions, again, please type them in the question box. We'll answer the ones we can. The ones we can't, we'll leave you with our contacts, and you can always contact us and we'll respond. Okay. The next question that we had is on NSSF and NHIF payments. Why was the employer not requested to remit to NSSF and NHIF? Since it's the employer to mandate. So I believe you're talking about a case and why they were requested to refund the payments that were not made. It's because the employer didn't make the payments initially. Why the court made that order is they didn't make the payments initially. And so it would have to be upon the employee to follow up again on those payments, which the employer had initially not made. So it was just easier for the funds to be given to the employee, and then the employee can have them remitted by themselves. We had another question on data collection. Washera, are you able to answer this? In the case an employer uses data collected without the knowledge or approval of an employee, what can the employee do to protect themselves? In the case of an employer using data without the
yes, so So in the event that an employee has the data collected without their consent, then they do have the right to report this to the Data Protection Commissioner. However, we are also willing to offer training on the bridge between the Employment Act and data protection, also for sensitization, just to ensure that we don't get to a point where we are breaking the law out of ignorance.
Thank you, Washera. Now we have a lot of questions on notice, so just a minute, I'll get to them. Again, Washera, can an employee ask for their data to be deleted or destroyed upon termination of the contract? So maybe that you can answer later. Let's move to the ones on notification. Emily or Victorine, what are the consequences of an employee leaving employment without notice soon after receiving their salary? And also when issuing a notification for an employee to attend a disciplinary hearing, how many days of notice are required? Do weekends count? For example, if an employee receives a notification on a Wednesday, is it permissible to conduct the disciplinary the following Monday? So basically, what is the notice period required? And then there was another one on notice. If you can just note all this, then you can just respond to all of them at once. If an employee resigns, do you have to pay the days for serving the notice, and also is severance pay a must? There was a last one on notice. Yeah, you can just answer those, Emilio, Victorine, on notice. And then there was an additional one. What happens to an employee who goes on maternity leave without notice? And what happens when an employee comes after leave and is assigned duties not under their original job description?
Thank you. So I could start with the one on disciplinary hearing. So the law does not expressly provide for the time frame. So here we apply the test of reasonableness. So, and when apply, different courts have handled this matter and stated that so you shouldn't invite the employee for a disciplinary hearing when they are on leave. So sorry about that. So I was talking about the disciplinary hearing. I was saying that the law has not expressly provided for the time frame that should be given. However, it's for the employer now to employ the principle of being reasonable. So for one, courts have held that you can't invite an employee to a disciplinary hearing when they were on leave. You should wait until they are done with their leave. So, and again, if you can't invite them on a weekend, if their working hours does not involve working on a weekend. So the test of reasonableness should apply. The next one was on severance pay. So if an employer decides to make a position redundant, they are liable to pay severance pay, and yes, it's compulsory. Severance pay is 15 days for every year of service. The other question was on resignation. So if I think the question was about if an employee decides to resign without, whether you're supposed to pay them for the notice period. Yes, they are supposed to be paid even when they are serving their notice period after resigning. With regard to an employee who comes after leave and finds themselves working on a different job description, the law provides that, and especially for maternity leave, when the employee comes back after maternity leave, they shouldn't be exposed to harsher conditions or less favorable conditions or working environment or all that to which they were doing before they went for the leave. So I believe we've answered that. The other one was on the employee who decides to leave without notice shortly after them receiving their payment. As I had said earlier, the employer can decide to go after them, claiming for the wages in lieu of notice. So Rosario, I don't know whether I answered all the questions.
I think so. Victorine, do you have anything to add?
I guess you can hear me?
Yes, yes.
All right, okay. I can just run through, I think at least see whatever question that has not been answered or just any additions that we may have. I think most of them have actually been tackled. I think this was quite a very involving exercise. Perhaps we may need to restructure it to give smaller bites to our attendees. So there's the question that you'd started answering, the one on NHIF and NSSF, and the fact that the court directed that this amount actually be refunded to the employee as opposed to being forwarded to the institutions. So various courts have had conflicting positions on this particular statement. For some courts, they've observed that actually NSSF and NHIF have better infrastructure and that they're the ones who should actually go after the employers for purposes of getting back that payment. But for most courts, and I think this is something that has also been reflected in the provision on service pay, because service pay is paid to an employee who was not registered under an NSSF. So it's not that the court would come back and now tell the employer, now all this money that is supposed to be paid to this guy as service pay, please pay it to NSSF. They want to give the benefit to the employee directly in a way that does not cause them to go over great lengths to try again and implement their right, and to try again and seek redress. So that's why the position is there, for purposes of just meeting the employee at an easier position and enforcing it. But yes, other courts have decided that way, that this amount should be advanced to the institutions, and or in denying the prayers from employees, courts have actually said that these employees can actually go to these institutions and ask them to compel the employers to refund the money. I think the other question that you had, you've clarified on housing allowance. There's something from Dad and Mariah about how much the employer is supposed to pay. I don't know if this is in reference to housing allowance or payment in general. So usually for payment in general, we have what we call the minimum wages. There's an order that's usually issued and revised. So that one, you can find it in terms of the minimum wage bracket that that is applicable for employees in Kenya over a certain period. But in terms of housing allowance, I think it had been mentioned in one of the presentations, and we'll share these slides. We note that because of how much the information was, at some point we needed to move faster. So maybe some of this information could have slipped here and there, but it will be shared in the slides. And for housing allowance is usually calculated as 15% of your basic wage. But what we advise you as employers is that in writing that clause in terms of the salary of an employee, please make sure that you have it in brackets that this amount includes a housing allowance component. That way you'd have satisfied this particular requirement in law. As regards the question on data collection, again, as Washera had pointed out, we are discussing with our data protection team on just having training for under employment law and the intersection with data protection law. But in terms of the question that has been asked here, in terms of can an employee ask or require that an employer deletes their document? So there has to be a balance of rights here, because if at a later date, this same employee comes to sue the employer would not be able to defend themselves against such a suit because they've deleted their records. So this is why we also emphasize that as an employee, there are certain essential policies, as an employer, sorry, there are certain essential policies that you must have. This would include the data protection policy. And this policy would provide the details on retention of information, deletion of information, update, seeking consent. All this has to be provided for, because as you can see, employment law is a touchy subject, and there are very many loopholes that can be exploited to your detriment. And the damages that are given, including the exemplary or punitive damages, are quite hefty. They go up to 12 months of an employee's salary. So it's important to keep your house in order and to preempt such a situation from arising. Because if you had a data protection policy, you'd have been able to advise the employee beforehand that this information must be retained for this particular period of time, so that they would not be able to require such deletion, unless, of course, if it's in furtherance of their rights, where they require, maybe if it's sensitive information, sensitive data, that does not, again, disenfranchise the rights of the employer when it comes to defending himself against that employee. I think most of it had been answered. I'm just trying to go through the questions and see if
there was one on maternity leave. Maybe you can touch on that one. The one where they went on maternity leave without giving notice. What would be the procedure to follow after that?
Okay. In terms of maternity leave, I think you'd covered it already, Rosario, in terms of, even though the law provides that, yes, you should give a 7 days notice. If they didn't go, but they've sent a bad notification or they notified you, because there's a difference between someone who completely disappears off the radar and you're not able to hear from them at all, and you can show that there were efforts to reach them and they've really gone away for a number of days. That's different from someone who's had an emergency, has had to go through maybe an emergency cesarean, or there's some complications with the birth, so that you give a certain allowance. Employment law is a very humane law, And these are the things that actually matter before a court of law. It is how did you treat your employees? It's not really about the letter. Yes, in certain aspects, it's a letter of the law, but also your disposition as an employer, how you're treated, even when it comes to things like sick leave, termination in case of long periods of ill health where you're incapacitated to the extent that you can't return for work. Your behavior, your disposition, your actions as an employer are actually put to test. So you have to be humane even in implementing some of these clauses. Regarding, I think there's a question by Karen. How is the employee protected from the non-compete clauses? If my position is rendered redundant, how am I supposed to get to do something completely different from what I have been doing for maybe almost 20 years? So for the non-compete, it's usually put there to protect the employer, not the employee. But there's also the caveat. There's also that qualification and a restraint of trade. And there are quite a number of cases. And I think you can engage with us even directly for purposes of seeing the balance, how you can use the non-compete clause in a way that still does not cross the line over to causing a restraint of trade that is restricted in law. If an employee resigns, do you have to pay the days for serving the notice? And also is severance pay a must? I believe Emily answered this question. I think the thing that I just need to point out is the distinction between the two, service pay and severance pay. Service pay is when your employer was not paying NSSF, or you're not registered to any pension scheme, or if you're registered, the remittances were irregular, service pay. Then you have severance pay. Severance pay is where your position has been declared redundant. Both of them are calculated in the same way in terms of 15 days for every year served, but it's very important to draw that distinction. So I think even in light of what Emily had talked about, that question has been answered in that regard. If an employee resigns, do you have to pay the days for serving the notice? If the employee is the one who has resigned, you're actually supposed to hold him on the same clause, because this clause is for both the employer and the employee, which is why Emily was talking about, if actually the employee leaves the day after you've paid their salary, you can actually go after them. And we've seen many employers, especially for highly paid employees, they actually go after the employee and tell them, you've left and you've not served your notice, so pay us in lieu of that notice. But you cannot have an employee resigning and then you also, as the employer, again pay notice. No, it does not work like that. Then I've seen on a fixed term contract, let's say 1 year, then on the 6th month, the employee does a gross misconduct. On termination, should the employer pay the remaining 6 months? So what you need to understand is, okay, there are two issues here. One is on the fixed term contract, and the second one is on termination of gross misconduct. So termination of gross misconduct, I think you can just look over the slide. I don't know, anyway, but you can see us, right? On termination on gross misconduct, which is what Emily had spoken about in terms of summary dismissal, you would not be required to pay notice because it's a summary dismissal. But what you have to be careful to do is you make sure that every step has been followed. Was there a disciplinary hearing? Was it a fair hearing? Was the employee invited to make their representations? Were they heard? Were they accompanied by another employee of their choice or a union representative in case they're unionized? So the steps must be followed. And if they're followed properly, there's no notice that is payable because it's a summary dismissal, as the word suggests. But on the other hand, if it's a dismissal before termination of the term, before expiry of the term, then one of the prayers that an employee would make is that you pay me for the period where I was supposed to have worked but didn't work. Here is if, for example, that fair hearing, quote unquote, that you conducted was found by law to not have been a fair hearing, then one of the prayers that the employee can make is that pay me for the remainder. It would not be fair for an employer to pay beyond those 6 months. So for example, if this employee had a 1-year contract and then they were terminated unfairly after 6 months, they cannot then ask for pay for 12 months because either way, the period within which you would have worked is just that 1 year and 6 months are the ones where you did get to work. So that's how the interplay occurs. I hope it's been clear. It's a number of issues, they're intertwined, but I hope the point is home. I'm trying to read on NCAs in employment contacts. What is NCAs?
I believe non-compete agreements.
Okay. Okay, is that clauses?
Yes.
Is reasonableness a factor to be considered so that it would be unreasonable for a former employer to bar a former employee from setting up a farm within a particular distance from their farm or
Sorry, you've
I'm
frozen.
back on this other side. Can you hear me?
Okay. Okay, yes, yes. Yes.
Can you hear me?
Yes, we can hear you now.
Okay, okay. I think sorry, I lost power on my machine. For non-compete, again, as we said, this is there's a line, there are certain provisions regarding restraint of trade, and of course, the provisions on non-compete clauses are not absolute. They have to be tempered, they have to be reasonable, because of course, if it's something unique, an area where your expertise is niche, you can only work in specific industries, you cannot completely restrict or prevent a former employee from being in the same industry. So there are certain, depending on the number of years that you've provided for, if for real this person cannot find work anywhere else other than within a particular set of industry or within a geographical area, there are certain limitations that have been imposed by court. You can reach out to us. I think we'll be able to address that in a much finer detail. I see we're already at 1 p.m. Sorry, Rosario. Let me just try and conclude. I think that had been answered in terms of an employee leaving without paying salary. We will, I don't know if we can share the recording, but I know we will share the slides. I think Rosario will advise. Can a consultant receive benefits like medical cover or housing? So if they're to receive such benefits, they will not be taken to be employment benefits. And it's also very important that you structure your contract in a way that this consultant cannot at any given time come back and say they were an employee. You see, the issue with consultancy contract, and the reason why it's very essential to divide these two, is because sometimes consultants may come back and insist that they were employees because they know that they will have more rights as employees. So if they're receiving the medical cover, is it as an additional benefit? How is it been put down in the contract? How is it quoted as a remuneration? How is it taxed? Would it be able to turn the contract into an employment contract? And then as you gauge against the other tests that you put your relationship against, would it fall under an employment? So it's important to just distinguish. And then again, we insist on very proper drafting, because sometimes you just call someone a consultant, but everything they're doing, how they're behaving, how they've been incorporated into the company shows that they're an employee. So it's important to have those two clearly provided for. Is there any defense against a claim of legitimate expectations? Yes, of course, there are a number of defenses, and most times what we say is preempt. Don't go to court and then decide on these things. So in terms of a fixed term contract, make sure that the option to renew
has to be rely on an application that is made by the employee at the end of the term. And then you evaluate as the employer, and then you extend the contract or you renew the contract. There should never be a clause on automatic retention, because that automatically, using the same word, but that automatically now creates a legitimate expectations. So for fixed term contracts, you also want to be very careful about how you provide for the renewal, if any, the terms on how it ends. Are you keeping time? Do you have someone who's having a record on this contract is supposed to end today? You're supposed to send in your application for renewal. I'm supposed to look at it, to vet it against our needs, to vet it against our cash flow issues, to vet it against how we're the trajectory or the projects that we are doing, and then now renew. That way you show that there's a clear stop between the contract for this year and the contract for next year. I think the question on the period, the notice for disciplinary hearing had been answered. The other thing I'd wanted to mention, if your company has, for example, I think the law provides for 50 or more employees, it's very important for you to have the codes and the disciplinary measures or the code of conduct or a handbook or a manual. I think in other jurisdictions, it's actually compulsory, and they have the code where they revert to in case you've not provided for your employees. But for ours, what we're trying to do, especially for employers who are attending this training, what you want to do is preempt. You don't want to get to that point and then start running around and looking for policies. So even for disciplinary hearing, I don't want to have, as Victorine, I have only, I got a notice for 14 days, but Rosario here got a notice for 21 days. If we had a policy on it, then any allegation on discrimination, any allegation on improper issuance of notice, any allegation on unfair hearing or unfair termination is kind of actually mitigated against if you have the right policies and the codes in place. Is the leave on paternity leave limited to a particular number of births, or does this apply to every birth that he is the father of with a proof, or are they required to have a proof of marriage to the mother? So what you're required to submit is the birth notification. Yeah, you're supposed to submit the birth notification when applying for this leave. But I was listening to a discussion where women were actually saying that perhaps men should have a longer paternity period, and one of the answers or one of the suggestions against this is because they could be having 5 children, and they have 2 children every 2 weeks, and then you're giving them 3 months for every at the end of this 3 months, if they're polygamous man, or if ako in Nairobi, sorry for that, but such things, you know. So that's why they were saying maybe that's why their time is really shortened to 2 weeks. But I know many human rights activists are actually pushing to have this paternity leave extended because they're equal parents. You're agitating for a more present father, someone who's helping with the child, someone who's helping at home. Because in the same way that women have been able to break the glass ceiling in offices, it's the same way the men have to break that kitchen door at home. So I guess it's a balance of sorts, but you just need to provide the birth notification for that application. An employee is on fixed term contract. I think I'll stop just shortly. If we've not answered any other questions, I think we can do emails or they can reach out to us. I believe we've left our contact. So let me just do this one as the last question. An employee is on a fixed term contract of 1 year. She proceeds on leave within the 1 year contract, but the employer is not willing to extend the contract. Can employer communicate to employee while they are on maternity leave, informing them that their contract will be expiring and will not be renewed? So if it's a fixed term contract that is properly drafted, there should be no expectations of renewal. Okay, that's where it ends. Even if you're going on leave this year and you're pregnant and it's on maternity leave, if your contract was to end in December and there had been no indication, no communication that it will be extended, then that's it. You have to work with having that. It's called a fixed term contract. So if there was, however, communication or there was a certain indication that caused the employee to expect that
contract could be renewed upon them coming back from leave, then that could be a justifiable claim for legitimate expectation. That's it
You're
from my
done.
end, Rosario.
Thank you so much. I can see the other questions. Abigail, I've seen your questions on the requirement of why you're required to notify the Labour Office of exit, death, and termination. I think we shall be reverting with that. So we've seen your questions, and thank you so much for joining our webinar. We've taken a bit of more time than we intended to, but I believe that we have been able to give out good information, which will be beneficial to yourselves. If you have any questions, kindly reach out to us and we'll be able to assist you. You can reach out to vrotich@cmadvocates.com, vrotich@cmadvocates.com for any questions that you may have. Thank you so much for joining our webinar. We shall be calling you to our next one, and we hope this has been an informative session for all of you. Thank you and have a lovely day and a lovely rest of the week.